Hello again, everyone. In this video we're going to talk about hanging beware of dog signs, and a lot of you have had questions on that. It's one of the biggest questions I get asked. And again, my name is Paul Goeringer and I'm the Extension Legal Specialist with the University of Maryland. Again, before we get started, I have to give my general disclaimer with this. I am an attorney. Nothing I say on this topic should be construed as legal advice. If for some reason you need an attorney, contact me. My contact info is at the end of this. Get in touch with me and I will help you find an attorney to do this. So to kind of give a quick overview on this topic, again, like I said at the start, I'm asked this question a lot of times. Does hanging a beware of dog sign create liability? This issue usually comes up when we're doing presentations on livestock liability, and this is sort of the natural question that many people ask. So by hanging it, are you admitting the dog is dangerous, or are you generally like me? You may have a dog and you just don't want people coming to the door bothering you, so you hang the sign to hopefully keep some people away. Or you don't have a dog and you just put the sign up there anyway. So to answer that question, we kind of got to do a quick little overview of animal liability in the state. And then we kind of have to look at how Maryland courts treated this in the past, and then we'll talk about how some other state courts have treated this in the past. You'd actually be shocked. This is not an issue that's been highly litigated. But to look at animal liability, there are two forms of animal liability, and I apologize, there's a lot of information up on the screen. We will, in the next couple of weeks, have a fact sheet available on this, but if you want to read more about it, you can contact me and I'll get you the information on that. But to start with, strict liability is one form of theory of animal liability. This basically means that whoever is injured by the animal has to demonstrate that the pet owner knew or should have known that the animal had the natural tendency to commit the particular act that was caused. So basically you knew or should have known that your dog had a tendency to bite. So it's either bit someone in the past or it's a breed that we would suspect you would know that has a tendency to naturally bite individuals. The other theory of liability here is negligence, and this is just where the injured party has to show that you are unaware of the facts that the animal had the tendency to do this, and that you failed to exercise some form of reasonable care in controlling that animal, or reasonable care in preventing the harm that was caused. So you didn't know your dog would bite, but you didn't restrain them when a stranger came in the house, or something like that. Or another example is, and this is actually a Maryland case, you have inexperienced riders out on a trail ride one day, and you pay no attention to the riders. All of a sudden one of the riders is thrown from the horse. You have no idea what happened. This is an area where you potentially have liability because you should have been paying attention if it can be shown that another trail person would have been paying attention in a situation like this. So now we kind of go back to the main topic of this. We've kind of given the overview of animal liabilities. So does hanging a beware of dog sign, is that a good idea? Does it demonstrate, as we talked about with strict liability, that natural tendency that they look for in strict liability? Is it going to be something out there with negligence that you could get hurt with? Well, I did a quick review of cases involving beware of dog signs. Maryland only has one court case that involves a hanging a beware of dog sign. And in that case, basically, the individual was walking around the property trying to find a way in. I can't remember if they were a thief or not, and were bitten by a dog. And the idea there was basically the hanging of the beware of dog sign didn't impose any liability on the owner for that happening. And in fact, the person that was bitten by the dog assumed the liability for what, or assumed the risk of being bitten by a dog. And the idea behind the assumption of the risk is that basically you know or should have known that this injury could have happened to you by doing certain things. So in this person's case, they should have known that by seeing a beware of dog sign that potentially they could be bitten by a dog. So that was the idea behind in this case where the court did that. But they didn't go into a lot of detail on that, so we're not exactly clear if that's the way that would come out. Other states, in looking at how they've done this, the basic idea there is it's just a factor in deciding liability. It's not the deciding factor. It's just one factor among many that we look at, including natural tendency. Has a dog done this before? How are you controlling the animal? Those sort of things. So it's not going to be liability every time if you hang the dog sign. It's just one factor we're going to look at in the end. So in the end, just kind of to summarize all this, there are two theories of liability involving animals. So we talked about the strict liability, we talked about negligence. is hanging and beware of dog sign is typically just one factor that the courts look at. And in Maryland, at least in one case, it's assumption of the risk, which is a defense to the negligence claim. So potentially you may have a defense if the dog bites someone coming on your property. I'm not entirely sure on that, but you potentially have that defense. Again, thank you for watching this video. If you have any questions, my contact info is on the screen. You can call me, email me, tweet me. Let me know if you have any questions, and if you have thoughts on other videos we should do, please let me know. Thank you again for watching.